What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I have got the conclusion of the doctor lawyer, the pro se doctor lawyer, who's been plaguing Judge Simpson's courtroom with pro se nonsense for what, 2 or 3 months now? It's one of the longer eviction cases I've ever seen, but this is the conclusion, and she does not go out without a couple smart words for Judge Simpson, and he does not take it well. Well, no, he takes it great. I take that back. He takes it amazingly and throws words right back at her to make her feel eh, like she earned. Okay, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
The case of, if I get it open here. It does call the case of R&J Group Holdings versus Saffold.
Good morning, Your Honor.
Morning.
Anthony Momina here on behalf of plaintiff R&J Holding Group Holdings LLC.
Azara Staffel, on behalf of myself and my family.
Okay, where are we on this?
Your Honor, this is our motion to seek distribution of the funds held in the court's escrow account related to this case. Just to recap, two $5,000 payments total, which was the lease payment amount, incidentally, were placed into the account pursuant to the standard escrow order that was entered during the pendency of the case in chief. And then subsequent to the issuance of a judgment of possession, there was an appeal, and Your Honor entered another order, a bond on appeal,
Yes.
under which two additional $5,000 payments were made into the court's escrow account. I've confirmed with the clerk that $20,000 is currently being held. There was an appeal, obviously, hence the appeal bond. That appeal was dismissed by the Washtenaw County Circuit Court. There was a subsequent appeal to the Court of Appeals that was processed as an appeal of right when in fact it should have been otherwise, and that court dismissed the appeal. So there are no pending appeals on this matter, Your Honor. The matter is final and closed. And as an administrative action, I would ask that the court authorize the distribution of those monies to my client. Thank you.
Response.
Well, according to MCR 3.31, this was an injunctive bond that supposed to protect both of us because we counter complained against.
Why was it it wasn't an injunctive bond.
Should have been, because we apply for restraining order against the plaintiff and it wasn't granted. But this plaintiff case still is in pending status with federal court, and we paid $10,000 security deposit. We want them back, and we also paid for over $44,000 of expenses that we paid the property taxes, we paid the homeowners insurance, we update and upkeep, and they even charge us attorney fees, Your Honor. And I have the sheet to prove it, and therefore we are entitled to this $20,000.
Why don't we get clear, first of all, what the $20,000 is? The $20,000 was escrow pursuant to the basically summary proceedings action that had been filed. That is not under Section 3 of the court rules. That is actually under Section 4 of the court rules regarding the issuance of an escrow order. I issued that order. You complied, as counsel has indicated, 2 months of that. there were two payments put in. Judgment was rendered. You appealed that judgment, also pursuant to the court rules. In again, chapter 4, you will see that the bond on appeal, I could have set it theoretically at whatever or whatever bond, but where there has been an escrow order, that escrow order then effectively becomes the bond on appeal. And that's what happened. And so then there were two additional payments prior to the dismissal of the appeal that then makes the 20,000. So that we're all, whether we're not on the, we can all be on the same page or not. That's what happened, and that's why the 20,000 is there. I don't know what you're talking about in terms of injunctive relief. I don't know any of that. That has nothing to do with me in this court. The purpose of that, and the 5,000 was the amount of the lease, basically the lease price of the premises.
Exactly.
All right. You were in possession of the premises up until such time as the writ. I don't know if the writ has been executed or not.
And
But-
the return has been filed by the sheriff.
Got it. So you would have had to have paid that amount to be in possession of the premises up until whatever point in time and during appeal. So I'll let you make additional argument, but it seems to me that the 20,000 should be paid over to the plaintiff because of your occupancy of the premises.
Permission to speak, Your Honor?
Go ahead.
All right, so it's fairly simple. $20,000 in escrow. She owes that much in rent. Yeah. Judge Simpson just nailed it. Yeah, we're gonna give that money to the homeowner. That's where we're at. You're being evicted. Now this is where she starts getting smart.
What about our security deposit, Your Honor? What about the payment of property taxes and homeowners insurance they forced us to pay in anticipation of the sale, which they breached the contract and they never did, Your Honor?
That would have to be taken up someplace else in terms of the property taxes and whatever. In regard to the security deposit, the security deposit is the disbursement of the security deposit is taken care of pursuant to an entirely different statute.
I beg your pardon?
There's the Security Deposit Act, which governs how that is how that gets returned and or not returned, what it can be applied to. That's not before this court.
Which court is this before, Your Honor?
Pardon?
Which court should I go and ask for return of?
I can't give you legal advice. I'm just saying that issue, I'll put it this way, that issue is not before the court. That has not been raised as the return of the security deposit. Usually is something that takes place after the tenancy. Sometimes it's dealt with during the course of a summary proceedings case, certainly, but that has not been raised here and is not before the
I'm
court.
raising that today, according to ex parte emergency motion and filed, Your Honor.
I don't know that it would be, I don't know that all of the compliance, Gustavo, the act is very specific about certain things that have to happen in order for an issue under the Security Deposit Act to be right to even be heard before the court. I'm not even sure all of that's happened. You can't just say, I need you to deal with this. That's not how it works.
Okay, I petition again, Your Honor.
Well, you can do what you want. Ms. Staffeld, I'm just telling you, I'm not dealing with the security deposit. I'm just not. It's not before me. The only issue before me is the $20,000. There's an escrow and its disbursement. Is there anything else you want to say?
Thank you for evicting me and my family out of our house, Your Honor. God bless you.
Well, I guess you're welcome. I didn't evict you. You evicted yourself by not complying with the lease. So don't try to put that on the court. Sometimes people, when they have problems in life, have to take the responsibility for their own actions and can't sit there and try to blame the plaintiff or blame the court or blame everybody else in the world. Those are the people that have real problems because they can't take it on themselves to do the right thing. So to the extent I made you realize that, you're welcome. It's the order of the court that $20,000 will be paid to the plaintiff. Counsel for the plaintiff prepare that order so that I can then give that to the clerk so we can disperse it.
Thank you so much, Your Honor. Appreciate your time.
We know this is gonna happen, so we are.
All right, that's it. Yeah, don't try to get smart with Judge Simpson. He's going to throw it right back at you. That was a great answer from Judge Simpson. I didn't like that. Like, oh, I'm going to throw all this guilt on you. It's like, no, you didn't pay your rent. Yeah, I'm sorry. That's where you're at. You put the $20,000 into escrow to keep this case going, which, but it's not your money. Anyways, thank you guys so much for watching. It does suck to watch an eviction happen. I'm not, saying this is a good and happy video. But I do agree with Judge Simpson. Like, yeah, you put this on yourself. So hopefully you've been making plans to move, because if you thought you were going to win this case, yeah, I think all of us watching knew that you had no chance from day one. And this is, I don't know, the fourth or fifth time I've covered this case. Anyways, that's all I have. Hopefully you liked it. Hit that like button if you did. Until next time, bye.
Submitting us to right now.